be removed from the state? Well, there are different ways that this can happen depending on your immigration history. The first way is if you've applied for international protection and been refused. When you make an application for international protection, there are three types of status that you apply for: refugee status, subsidiary protection, and leave to remain. If you're refused each of these, then you'll be given the option to voluntarily return to your country of origin within a certain period. If you don't choose this option, then a deportation order will be made against you. It's important to note that the making of a deportation order in this situation happens automatically. If you have not applied for and been refused international protection, then the other way a deportation order could be made against you is under Section 3 of the Immigration Act 1999. This section lists certain categories of people that a deportation order can be made against. Before a deportation order can be made against you, though, you must be given a letter that gives you a number of options. This is often called a 15-day letter. The first option that you're given is to make representations within 15 working days as to why a deportation order should not be made against you. If you choose this option, then the Minister has to consider your representations along with certain other factors, which include the duration of your residence in the state, as well as humanitarian considerations. Your legal rights also have to be considered. These include a right not to be returned to your country of origin if you be at risk of certain harm there. Other rights must also be considered, including rights under the Constitution and the European Convention on Human Rights. And if removing you would result in a breach of these, then you can't be removed, so a deportation order can't be made against you and you must be granted permission. The second option given in a 15-day letter is to leave the state before the Minister decides the matter. If you choose this option, then you must inform the Minister in writing and give details of your travel arrangements. The benefit of choosing this option is that a deportation order will not be made against you. This may possibly preserve your right to re-enter the state at a later stage. The third option in a 15-day letter is to consent to the making of a deportation order. If you do this, then you must be removed within 3 months of the making of the order. If this is not done, then the order ceases, but this doesn't necessarily mean that you'll be granted permission. Instead, it's possible that you may be issued with a new 15-day letter. If a deportation order is made against you, then you'll be given a date to present. It's important to note that if you fail to comply with this, then you could be subject to arrest and detention, but this must be done lawfully. It's possible to apply for revocation of a deportation order where there are new facts or circumstances since the time the order was made. If you're a family member of an EU citizen, then in certain circumstances you can only be removed from the state by way of a removal order. This differs to a deportation order as it expires as soon as you're removed, which means that in certain cases you may be able to re-enter the state at a later stage. A deportation order, on the other hand, is indefinite in duration, so once it exists you can't re-enter the state unless the order is revoked. If you have any queries or concerns about deportation orders or any other immigration issues, come and talk to us at Young O'Reilly & Company Solicitors for immediate legal advice and representation.